case briefs, and so much more. LSData's got what you're looking for.
When a car buyer changed their mind about a purchase, it ended up sparking a legal clash that reached the Appellate Division of the New York Supreme Court in 1937. The car dealer, seeking compensation for their perceived losses, resold the car but filed a lawsuit demanding the recovery of damages for loss of gross profits. This case, dubbed A. Lenobel, Inc. vs. Senif, tested a basic principle in contract law. If a buyer breaches a contract, any claimed damages by the seller are limited to the difference between the agreed contract price and the current market value of the item. Claims for damages connected to lost profits are excluded unless a specific agreement with the buyer is in place. The legal confrontation started when the buyer tried to cancel the contract shortly after it was made. The dealer responded by refusing to cancel, reselling the car, and then claiming damages of $226.50, an amount which represented their loss of gross profits. In the subsequent trial, the dealer's claim was thrown out and the buyer was awarded the return of their deposit. However, this decision wasn't the end of the line for the disputing parties. The dealer appealed, leading the appellate term to reverse the judgment in favor of the buyer and order a new trial. Central to this appeal was the question of how to properly calculate damages in cases of contract breach. Going forward, the court deemed irrelevant the dealer's evidence of overhead expenses in relation to the measure of damages. In the end, the Appellate Division veterans upheld the trial court's decision to dismiss the dealer's complaint, and they also stood by the reversal of the initial judgment on the buyer's counterclaim. The court emphasized that the plaintiff, the dealer in this case, could have sought other remedies, such as a larger down payment or incorporating special circumstances into the contract as stipulations. The justices clarified that while providing evidence of specific expenses related to a particular resale is not ruled out, demonstrating such expenses requires more than just gross profits or general overhead costs.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.